Good afternoon, and welcome to CCK Live, Facebook Live. Today we're talking about the top 5 VA errors. My name is Robert Chisholm. With me is Jenna Zelmer and Nick Briggs. And we're going to talk about the top 5 VA errors. If you have any questions during this presentation, please reach out to us on Facebook Live and we'll try and answer them to the best of our ability. By the way, the VA commits more than 5 errors, but we thought we would start with these top 5.
And these are broad categories themselves.
Yeah, I think they're technically more than 5. There are 5 categories of errors.
So let's jump into the first category, and the first one, and I think it would be my top one. We kind of debated what the top 5 were, but this would definitely be my top one, and that's TDIU errors. So Jenna, do you want to sort of hit what TDIU is and talk to us a little bit about how VA makes mistakes in that area?
Yeah, thanks, Robert. So TDIU stands for Total Disability Due to Individual Unemployability. VA awards TDIU to veterans who can demonstrate that their service-connected disabilities prevent them from obtaining or maintaining a substantially gainful employment. Essentially, what we usually say is that if your service-connected disabilities prevent you from working, you can be entitled to TDIU. There are some nuances within that term, substantially gainful employment, which VA gets wrong a lot. So the first error that we see a lot of is VA considering factors that they are not supposed to consider when they make that determination. So, for example, if VA considers a veteran's age, say that the veteran is 65 and retired because they had reached the age of 65, VA would say, oh, well, you retired because of your age, you're no longer working because you're 65, we're not going to grant you TDIU because it's not due to your service-connected disabilities. But VA isn't supposed to consider that in their determination. They're supposed to ignore the age, ignore any reason why the veteran retired, and just focus on kind of in a vacuum. If the only thing was the service-connected disabilities, would those prevent the veteran from working?
So can I just sort of ask a hypothetical? Let's suppose I were a 90-year-old World War II veteran. I retired, say, at age 68. But now my back condition that's related to service prevents me from working. Mm-hmm. Would that veteran then be eligible to apply for TDIU, even though they're 90 years old?
Yes. So if the service-connected disability would prevent you from conducting the requirements of a job, so if the back prevented you from working, prevented you from going in on a reliable basis, bending, lifting, all sorts of things that are limitations of your service-connected disability, then yes, regardless of your age, regardless of when or why you retired, you can be entitled to TDIU.
And that's a good example to give because that's often how they obscure the fact that they're considering age. They'll say that the veteran retired 30 years ago and use that to imply that they can't work for that reason, when in fact they're considering something they shouldn't be considering.
Are there other factors that VA will consider that they're not supposed to consider in TDIU cases, Nick?
So one of the most common ones is non-service connected disabilities. So a veteran might be service connected for PTSD, but they have a non-service connected back condition, and the VA will turn around and say, well, no, you're actually unable to work due to the back condition. But this is another one of those things where the regulations say consider service connected disabilities only. So they essentially commit error by considering these conditions that aren't related to service.
So theoretically, someone could have a back condition that's not related to service that prevents them from working and have a separate, let's say in this example, you're talking about a psychiatric condition.
Sure.
That is related to service, and if that prevents them from working, then they're entitled to TDIU.
Yeah, and in that specific case, they're entirely different types of impairment. We're talking the difference between exertional and non-exertional limitations. And then even still, there might be a situation where a service-connected disability and a non-service-connected disability have overlapping limitations. And in that situation, the court has said basically that you need to attribute all of those limitations to the service-connected condition. So it's always something to be on the lookout for.
So that last one is tricky. So let's give an example of a condition where a veteran has 2 conditions and they can't sort it out. Mm-hmm. Can you give an example of that?
Sure. So a veteran might have a service-connected back disability with bilateral lower extremity radiculopathy. They might also have non-service connected diabetes and lower extremity peripheral neuropathy. In that case, they have two separate sets of conditions that affect their legs in different ways, but ultimately they're going to have the same type of impact, affecting the veteran's ability to walk, to stand, so on and so forth. But in that case, VA really isn't going to be able to parse those impairments out, so they're only supposed to attribute those impairments to the service-connected condition.
So I'm remembering a case I handled a number of years ago where the veteran had a non-service connected dementia, but was also service connected for post-traumatic stress disorder. And VA attributed all his symptoms for the TDIU analysis to the dementia. And the psychiatrist said, I can't sort out what's related to PTSD and what's related to dementia. And after a couple of rounds in court, we were ultimately able to get that veteran the TDIU award. So those kind of examples happen more frequently than one would imagine.
Absolutely.
All right, so the next group of errors, Nick, is, and by the way, we're going to go back and go through some recommendations of how to address each of these errors. But we're going to go through the common ones first, the top 5 ones. So Nick, next up is orthopedic errors. Do you want to talk a little bit about that?
Sure. So one of the most common things that we see when it comes to orthopedic disabilities is the fact that the rating criteria generally revolves specifically around range of motion measurements. So if a veteran has a back disability or a knee disability, they're only going to be rating the disability according to whatever their range of motion is measured to be at the time of the VA exam. But other regulations tell them that they're specifically supposed to consider not only the range of motion measurements, but also all of the specific impairments that the disability causes in terms of how it affects their ability to bend, push, and pull items, things like that. So, yeah.
Okay. Do you have anything to add on that, Jenna?
No, I mean, I think that Nick really covered it. In addition to the objective range of motion, the theory there is really that a veteran can bend to a certain degree, maybe in an objective clinical environment where an examiner is watching them or helping them bend, but in their everyday life, they might experience flare-ups. Their pain might begin far earlier than where they can actually bend. And so those are all types of things that VA needs to consider, and they often don't. They only kind of look at the objective numbers and not consider the whole disability picture and how this would translate to a veteran's everyday life.
Okay. Again, this is CCK, and we're talking today about the top 5 VA errors. And if you want to reach out to us with any questions, please feel free to do so on Facebook. All right, number 3. I feel like for the last 30 years I've been dealing with number 3. VA exam errors. There's a lot of case law on this, but Jenna, why don't you tell us in general terms what we're talking about when we're talking about VA examination errors?
Yeah, so this is actually a good transition from our previous group of errors, which is about how I mentioned the board has to, or the VA has to consider not just objective range of motion measurements. And so one of the biggest errors is when a VA examiner is only conducting those objective range of motion measurements and not eliciting more information from the veteran about how his back disability, for example, or really any orthopedic disability affects him in his everyday life. And so in addition to just using, I think it's called a gonometer, it's like it's a tool that they use to measure range of motion. Instead of just using that, the examiners are actually supposed to get more information from the veteran, either in his lay statements or by repetitive motion testing to make sure that there is a complete picture of the veteran's true functional loss. And so that's a big one in orthopedic disability claims. The exams are often missing really important, vital information that the VA needs in order to properly rate the veteran.
Any other thoughts from you on that topic, Nick?
She mentioned near the end the orthopedic examiner's failure to consider lay evidence, regarding the orthopedic disability specifically. But that's a pretty broad category. The VA examiner's failure to consider lay evidence is something that you'll see in almost every type of examination. Oftentimes, a veteran might treat for a disability in service, but because they didn't treat for many years thereafter, the VA examiner might say that because they didn't receive medical treatment for the condition, it's not related to service. It's a relatively new disability. But the veteran might have said, no, I've actually had back pain for 30 years. I just never sought treatment for it, they need to consider that information, and oftentimes they don't.
And that happens a lot because I think a lot of veterans tend to suck it up, if you will, or just self-treat. And so a lot of veterans are missing treatment records for a number of years, but that doesn't mean that they weren't experiencing that pain.
Okay, the next general topic is about effective date errors, and we're talking about effective dates. We're talking about the date that the VA starts paying a veteran once they award benefits. And the general rule is that the date of the application for benefits governs the date that the VA will start paying. But what kind of errors do we see when VA assigns an effective date?
Yeah, so I think you mentioned the general rule about effective dates. I think we have an entire Facebook Live that kind of delves into all of the nuances about effective dates. Can be a little bit tricky, but the biggest error I think we see is going back to TDIU. So as I mentioned, TDIU is awarded when a veteran can no longer work due to his service-connected disability. So often what will happen is a veteran will file for TDIU in conjunction with an increased rating claim. But VA will make an error because it'll treat that request for TDIU as a new claim rather than as a part of the original increased rating claim. And so when they assign TDIU, they'll assign it just on the date that the veteran requested IU. And VA often requires a form called the VA Form 218940. And so the day the VA receives that form is generally the day that VA is going to assign that date. And that's not necessarily the right date.
All right, so let's try an example here. And we do have a question from Lexa, and we'll get to that in 1 second, but I'd like to give a hypothetical here. So let's say that a veteran filed a service connection claim for a back condition, and it took the VA a long time to get service connected awarded. Let's say he files in 2014, and in 2016 the VA rates it, but they don't award TDIU. And in 2016, the veteran says, look, you gave me a 60% rating for my back condition, but I can't work, and I haven't been able to work since I first filed my claim. What would VA typically do in that situation if the 8940, the form you were just talking about, was filed in 2016? But the claim dated back to 2004.
And it was an ongoing claim stream.
And it was an ongoing claim.
There were a lot of dates in there. I was trying to keep an eye on it. So VA should theoretically look at all of the evidence going back all the way to that initial claim for service connection and determine when the veteran's now service-connected back disability prevented him from working. So if he filed that claim, when did
2014.
2014, and he wasn't working as of 2014, and he says it's because of his back, they should get it all the way back to 2014.
But the problem is they generally are awarding it only effective the date the application is filed.
Exactly.
The 8940.
Exactly.
Okay, we have a question from Alexa. Would it be a VA error if they looked at my rating for left ankle, left hip, and left knee, each being at 10%, but is labeled as one medical issue? How would you prove this as an error?
So it's unclear. The first thing that comes to mind when I read this question is if she's only getting 10% for those three disabilities, and there is a VA rule that if you have multiple disabilities that are non-compensable, you can get a 10% just because VA recognizes that you have all these service-connected disabilities that otherwise wouldn't meet the criteria to have a compensable rating. So that might be what's going on. Do you have any thoughts?
So I wasn't clear. That was my initial thought. Was it 3 zeros that then equals a 10? But if each one of those conditions is separately service-connected at 10%,
then I wonder if it's all due to the same kind of occurrence in service. Maybe that's what happened when VA said it was all due to the same underlying medical issue. Do you have any thoughts?
Yeah, I mean, it's going to depend on the situation. I think if they really are each assigned a 0% rating and they're combined to 10 because you have multiple non-compensable ratings, one thing would one good idea would be to look into raising 4.59, assigning a 10% rating based off of pain in each one of those joints.
Right.
That's a way to demonstrate to the regional office that they might have committed an error if they really did just give you the 10% rating. They're really not supposed to lump different joints, different areas of the body all into one place like that.
Right. So that I would encourage you to reach out to either a service organization or an attorney and have them kind of look at the rating decision and kind of figure out. I think we need to have a little bit more facts before we know really whether or not the VA erred in that case.
Before we go down to error number 5, Philip's asking, in the hope of contesting a poor comp and pen exam, or CNP exam, what's the most efficient method for obtaining the CNP exam notes that were performed by a government contractor? So you are entitled to ask for a copy of the exam. And that VA is required by law to give you a copy of that if you request it. Now, they don't have to turn it over to you unless you ask for it. Now, when you say notes, I'm assuming you mean the report, but you may also mean what did the doctor literally write down. I don't know whether or not you're entitled to those notes or not. You can certainly ask for them and explain that during the exam the doctor wrote notes down and you want not only the report, but the notes. Typically, the doctor will say, my notes are incorporated in the report, though, as a practical matter.
You also specifically mentioned the fact that it was an outside contract examination.
Yeah.
One thing to keep in mind there is that it often takes a longer period of time for the VA to get a copy of that exam back, whereas they might have an in-house one within a few weeks. It might take a few months to get a complete copy of that report. So if and when you do request your exam, make sure to keep following up so that they do send it to you.
That's a really good point.
Yeah.
Okay, the last sort of general area of top 5 VA errors is psych condition errors. Who wants to tackle this one?
So I'll start, and then I think we can. Yeah, this is a tough one. So VA's rating schedule for assigning ratings for psychiatric disabilities is pretty broad. It's very vague. It has a lot of different types of symptoms in each level of disability. And so a big thing that we see when VA is assigning a rating for PTSD, for example, or depression or anxiety, is that they either add qualifiers to some of the symptoms that are in those codes. For example, they'll recognize that the veteran has suicidal ideation, which would potentially entitle a veteran to a 70% rating, assuming suicidal ideation comes with a certain level of impairment. But they'll say, even though he has suicidal ideation, he only has it once every couple weeks, or even though he has suicidal ideation, he's never expressed an intent to act on it. And those sorts of qualifiers aren't in the rating schedule. So the rating schedule just says, generally, if a veteran has X, Y, and Z symptoms, and one of them is suicidal ideation, and that results in, occupational and social impairment, raising to a certain level of, deficiencies in most areas, then that's going to be enough to get a 70% rating. So if all else being equal, and then the VA says, well, he doesn't have active suicidal ideation, so we're not going to grant him the 70%, that's an error. Do you want to take the kind of other side of the coin there?
Yeah, so another common example we see is them ignoring qualifiers that the regulation does include. So the most common example is the idea of the ability to establish and maintain relationships, but the regulatory criteria specifically say maintain effective relationships. So VA will often say, well, the veteran's been married for 30 years and has 2 children whom he speaks with. But does that mean that the relationships are necessarily effective? No. They might have problems. They might have stuck it out regardless of any issues that they have at home. And VA needs to consider that information. It's not enough that they have these stable long-term relationships that they just wouldn't end necessarily.
Yeah,
so.
Especially familial relationships. There hasn't been a precedential decision on this, but the court has, from time to time, made it clear that family relationships aren't necessarily evidence that the veteran is able to maintain a relationship. It's more evidence that the family member is, willing to support and stick by this veteran, regardless of their inability to kind of properly relate to people.
So one of the other things that seems to happen is the VA in awarding service connection, or I should say adjudicating service connection claims, will raise the bar for claims that aren't post-traumatic stress disorder. So for post-traumatic stress disorder, you generally need to show evidence of a stressful event, and have, under certain criteria, outside evidence, not just the veteran's lay statement. Sometimes, for service-connected psychiatric conditions, VA imposes that on other psychiatric conditions, for example, depression.
Right.
And that's another error that we seem to see all too frequently.
And part of the problem there is the ubiquity of PTSD. Oftentimes, it's the one formal mental health diagnosis that our veterans are familiar with. So they claim PTSD not knowing that they might have an anxiety disorder, depression, or something else. And oftentimes, the VA will deny a PTSD claim and ignore the fact that the veteran has a mental health disability that is related to service. And that's something that they're not supposed to do either.
Okay, let's go back through the 5 general areas and come up with some solutions to these common errors that we see. So first of all, with respect to TDIU, if someone's reading a rating decision that mentions age, what should they do?
At the end of the day, you're going to want to point out the fact that they can't consider age.
There's a case called Pratt v. I believe it's v. Derwinski, and that is one of the cases that kind of set out that these are irrelevant factors that the board or VA is not supposed to consider. VA also has internal guidelines that direct VA employees not to consider these, but everybody makes mistakes, so that's why we're here.
Okay. And similarly, if VA is considering non-service connected disabilities as the reason to deny a TDIU claim?
That's Pratt as well.
Yep.
It's sort of a good catch-all for any extraneous factors that VA is not supposed to consider.
Generally speaking, if you're awarded TDIU, you're not working, but there are some circumstances under which you can work and still be awarded TDIU. An example of that is marginal employment, less than the poverty threshold. If VA doesn't consider the fact that you're making, say, $8,000 a year as opposed to $25,000 a year, what's the remedy there?
So yeah, VA will often say that's when I was mentioning it before, I mentioned there is some nuance in the term substantially gainful employment. So just because a veteran is working doesn't necessarily mean they can't get TDIU, but VA will often stop the analysis right there. They'll say, well, the veteran is working, so we're just going to deny it outright. And so if VA does that, but you know that you're making below the poverty line, you can obtain your earning statements from the Social Security Administration, and you can also submit tax information, anything that would demonstrate to VA that you're actually not making above the poverty line.
Great. Okay, the next general topic of errors was orthopedic claim errors. We talked about only looking at objective range of motion. What is the solution here?
The easy answer here is lay statements, both from the veteran himself or herself and their family members. One, the veteran's the most competent person to testify to how their pain affects them on a day-to-day basis. And then their family members can also witness these things. And that corroborating evidence can go a long way in showing VA that the disability is more severe than the range of motion actually reflects.
I think Philip actually anticipated this.
Yeah, I think you did as well.
Because another option in conjunction with submitting lay statements is to obtain a copy of your exam. That way you know exactly what the examiner said, and you can point out any kind of blatant errors if the examiner got a fact wrong, if the examiner accidentally transcribed a number wrong, things like that you remember you told the examiner X and they actually wrote Y. That's a great way to make sure that anything you told the examiner is accurately portrayed.
What if I have a back condition and I got pain running down my leg, radiculopathy, and the VA only rates the back condition but not the radiculopathy? What happens in that circumstance?
Sure. You're entitled to a separate rating for that condition if it's related to your back. In that case, it's important to point out to VA that you are experiencing all of these additional problems that you believe are related to your back. Ultimately, the VA examiner is going to need to address it. But then again, the veteran's competent to report the pain that they experience, and pain alone can be a disability if it has functional impairment. So your best bet, as always, is to just over-report the things that you experience and then let VA figure out whether or not it's related to the service-connected disability.
Yeah, and I think you make a really good point that a doctor ultimately has to address these things, but a doctor's not going to address them unless the veteran reports them. And so it's really important to state what your symptoms are and let the doctor know that. Okay, for VA exam errors, we talked about flare-ups, active versus passive range of motion. The other thing is weight bearing versus non-weight bearing. Can you go through some of the things that one can do about those errors?
Yeah, so like I mentioned, the first thing to do is get an exam, a copy of your exam. Those type of measurement errors can really mostly be solved with another exam. And so if you have a private examiner, you can have them make those estimates and make those measurements if a VA examiner didn't do it. You can also ask VA to order a new examination that actually goes through the required measurements. And then, like Nick said before, exams that are maybe based on more a lack of treatment or a lack of adequate rationale, you can use lay statements to kind of bolster why you think the examiner was wrong on a certain factual premise, or why the examiner didn't really address your specific circumstances, your risk factors, things like that.
Sometimes a medical examiner, Nick, will say there was no treatment in service, therefore I can't find the condition is related to service. What about that? Does there have to be treatment in service to win a claim?
No, there doesn't. Again, the veteran knows what they experienced in service, and they're competent to report that they experienced pain in service. Oftentimes, they wouldn't necessarily seek treatment for it. One, because they were discouraged by fellow service members. They felt that they could be subjected to ill treatment if they sought treatment for their disability. So oftentimes it's just not there. Yeah. But VA still needs to consider their reports, because unless there's evidence to the contrary, their reports can be credible and supporting evidence enough on their own.
Okay, effective date errors. Let's take the first one where a claim has been pending for 5 years. In year 4, the veteran files, he's been rated but not rated high enough, and he wants TDIU, files a new claim in year 4, and the VA only grants it from that date. What do you do in that situation?
So I think the first thing a veteran can do is cite to Rice, which is a case that basically laid out what I had mentioned earlier, that a claim for TDIU is a part of an initial claim for either service connection or an increased rating. So when a veteran, during a claim that's pending, raises TDIU, VA needs to treat that TDIU request as a part of the original claim, and Rice goes through that. And so if you direct VA's attention to the case law, hopefully that will kind of set VA down the right path. And then another option is really just to, again, provide lay statements. I feel like we're broken record, but explain, even though you only requested TDIU on a particular date, explain everything that led up to that, and any specific dates that you remember when you experienced worsening, any dates that you stopped working, anything like that. And not just your only statements, family members, former employers, and coworkers can be really helpful.
There's often some overlap between veterans who are disabled for Social Security purposes and VA purposes. So it's oftentimes a good idea to point them in the direction of your Social Security records, which can often show, one, when you stopped working, and whether or not it was due to your service-connected disabilities.
Another effective date error that happens is the veteran will say, my condition worsened. It'll take them a year to get an exam, and then VA only awards the start of the higher rating the date of the exam. But the veterans had the symptoms right along. What about in that situation?
It's a similar solution to the TDIU problem. So, presumably when you filed your increased rating claim, you thought that your condition had already worsened at that time that you filed your claim. And so it's really helpful if you're continuing to seek treatment and have a treating physician who's documenting kind of the evolution of your disability, so that when VA incorrectly awards you a date from the day of the exam, you can point to medical evidence before that demonstrated a worsening. But again, you can also submit lay statements about when you observed a worsening. But I would just, make that argument that your condition didn't magically worsen the day that you went to a VA exam.
Okay. So the last category of cases is psychiatric conditions and mental health conditions. And one of the things I wanted to hit here is many times, especially with the service connection claims, the rationale is not adequate. And is there a particular case that you can think of where rationale, the court has talked about the rationale?
Do you want to take it? Do you remember?
For ratings or for service connection?
For anything.
For anything, really.
So
it's for everything.
Nieves, Rodriguez,
Yeah.
Steffel versus Nicholson,
Yep.
they all speak to the basic idea that the examiner needs to provide rationale for their conclusion.
Right.
They can't just state something,
Right.
which often leaves them open to criticism, because if they don't give an explanation, it's easy for the veteran to turn around and say, well, this, and this.
Mm-hmm.
And if they don't address it, the exam's not adequate.
Right. And we see that all too
We
frequently.
do. Yeah.
So what about the thing where we were talking about where PTSD does require a stressor, but depression or anxiety do not require a stressor, and the exam asks for it? What do we do in those situations?
So, you kind of have to make a legal argument that the two are different, that VA treats PTSD differently and holds it to a higher standard. A lot of times we'll see VA exams that are, trying to provide an opinion on a nexus between depression, for example, or anxiety and service. And the examiners will even say, well, there's nothing to corroborate the veteran's statements that these things happened to him in service, that he experienced anxiety in service, or that he experienced something that later led to anxiety. And so you really just have to make the argument that that's the wrong standard for both the examiner and for a VA. All the VA examiner needs to do in that instance is determine whether it's as likely as not that whatever he experienced in service is related to his current disability now. And so, make that argument.
And lay statements come into play there as well. Again, the veteran's competent to report that they had these symptoms in service, and oftentimes their family members will recognize a complete shift in their personality when they come back. And that's good evidence alone of problems that may have developed in service. So it's always good to get that in there whenever possible.
Mm-hmm.
Okay. Before we sign off, are there any more questions? No more questions? All right, so a couple of things here. We've discussed a number of cases today. So we'll provide the names and the citations of those cases on both our website and Facebook at the end of this. So you can use those cases, and hopefully you've learned that lay statements are very important. And the more evidence you put in writing to the VA from you or family members or friends, the better for your claim, ultimately. Any final thoughts, Jenna?
Nope.
Nick?
I think you covered it.
Okay, so again, thank you for joining us today at cck-law.com on Facebook. We do these once a week, so tune in again for the future. And we have a new legal podcast as well, so you want to listen into that as well. And you can find that on our website as well. Thank you.